Okay, welcome back. Today on the program, I'm joined again by Attorney Matthew Underwood of Madison, Wisconsin. And Matt, thanks for coming back on the program.
Yeah, thanks for having me, Tom. It's always great to do these shows with you.
And it's lovely today to film next to the Golden Gate Bridge. I always enjoy my trips here. So lovely weather. I hope you're enjoying it, Matt.
Oh, absolutely. Yeah, it looks like the sun's going down or coming up, one of the two, and yeah, beautiful sky right for us. So
We never stop working filming these videos. So
yeah.
today's question has to do with farmland, and the writer asked the following. My brothers inherited our family farm. The property was never split. My brother left his half to me. How do I claim it?
Yeah, so this is a good question, and it comes up a lot, especially being in Wisconsin. And some of these family farms that we deal with, they might have been in the family for generations. Some farms can be family century farms, so there's a lot of history with a lot of these farms, and continuing that legacy is a goal for a lot of those Wisconsin farmers. So these situations can be a little bit tricky, especially when we're dealing with multiple beneficiaries, and maybe those beneficiaries have different wishes. Maybe some beneficiaries want to stay on the farm, others would rather have that farm sold and then take proceeds. So these can be tricky situations where it's helpful to have a qualified estate planning attorney to help out. But in this question, so we have a situation where maybe mom and dad passed away and left that farm to their children. And now one of those siblings, one of the children passed away and then left that interest in the farm to another sibling. So just for this example, let's say that there were 4 kids and then mom and dad left the farm to those 4 kids, and one of those kids passes away and leaves it to one of the other siblings. So what happens is that beneficiary will essentially step into the shoes of that deceased owner. So if that sibling owns 25%, now that sibling who's inheriting it can step in, and now they own that 25%. So in this case, if there's 4 kids, one passes away, and one of those survivors inherits that interest, we're going to have 2 beneficiaries with 25% and 1 beneficiary with 50%. So that's not the end of the story. That's just how things will work in terms of estate planning law, but we really need to go through a process to clean up title to that farm. So we can't just leave things as they are. We need to make sure that that beneficiary's name goes on that farm title, and then whoever passed away, we need to remove their name from that title. So the process that we go through, it really depends on how that estate is situated. If the person who passed away had a will, or maybe they don't have any sort of estate plan, we might have to go through probate court, and during probate is when we'll clean up title and make sure that that new owner gets full credit for their interest. If there was a trust involved, or maybe just by the way the deed was set up, there's some survivorship rights. There might be different processes that we'd have to go through depending on how that property was structured. So without knowing further, it's hard to say what the best and most efficient route is, but a good estate planning attorney will let you know what your options are and then help you find the best path forward that's efficient and that will get things done. So Tom, I'll turn it back over to you and just be interested to hear your thoughts. And being in the Eau Claire area, you must run into these issues quite often dealing with family farm situations.
Yeah, I think this question, there's not a lot of details, so you pinpointed exactly my question. It'd be, if I could talk to the client, I would ask them, how did you receive this interest in the farm? And by how, I mean, what type of document? So if it was a deed, can you show me a copy of that deed? If it was through a will, let's look at a copy of the will. If it was through a trust, let's look at a copy of the trust. And then from there, we can take one of those pathways you mentioned and find the most efficient way to get the deceased person off the title and get it into the hands of, it sounds like, the other brother at this point. So I think whether you're working with Matt or with me or another estate planning attorney, if you can help gather those documents and bring them to us, we can always take a look, and then I like to just lay out your options and we find the best way to accomplish your goals. So I guess that's what I would ask for. Same thing as you, a little additional information. It's probably in one of those documents. And if you send it to the office, we can take a look and get started on it with you.
Yeah, absolutely. I think when clients are prepared and are well organized, that makes our meetings with our clients that much more efficient. So yeah, absolutely gather any information that you might think is important to this situation, bring it to the attorney's office, and then go through it, and then you'll get your answers.
Absolutely. Well, thank you to the writer for the question, and thank you, Matt, for joining us.
Yeah, thank you, Tom.
Thank you, everyone, for watching, and we'll see you next time.